to know our roles. The Constitution is very clear. Our mandate is very clear to legislate, but to legislate and make good law, to ensure that there's rule of law, and to capture and protect the enshrined rights of individuals. This is not basically a favor. It is a constitutional mandate. What is happening now in Parliament? We are now hostage of the executive, specifically President Museveni. The NRM caucus should now at least talk to their leader to understand that there are two different organs. We are an organ which is supposed to be independent and to perform functions without any directions and control. Harmonization of roles, that is okay. We can sit with the executive to harmonize roles. How do we ensure and perform as constitutionally directed? So what is happening now here, we don't have a parliament. We have parliament under the whims and wishes of the executive. So in the process, we are not making law for the community or Ugandans and citizens generally. We are making laws to protect an individual in power, and this is unacceptable. Yesterday what happened, I think, is an indicator of what is happening generally in Parliament. There is nowhere in the entire world where law is passed without consultation. There is no urgency. It's not an emergency situation. So it's like we are fighting Ebola. No. You cannot subject people, ordinary citizens, in a military court, which is a military tribunal or disciplinary committee, when there are other courts to hear and determine those matters in the issue. So it's very unfortunate that we are really here to debate what processes to take in court. Those are administrative issues. We should be now really looking at laws to protect the rule of law, to ensure development, to ensure there's food on the table, to improve on the health system and the infrastructure generally, something developmental, but not something petty. This is something administrative really. It should not even come to Parliament.
How best would security matters be protected? Because it looks like the spirit was to safeguard.
There are no issues of security. The Constitution clearly gives specific mandate and docket to different areas. The Army's protection of our borders and general security is clear. So if there are disciplinary issues, we have no problem with a military tribunal or disciplinary committee in the form of their court hearing those matters to try and control and guide the military. Matters to do with the civilians, since they're enshrined in the rule of law and the spirit of the Constitution, which is protection of individual rights and property, that has to be protected in a civilian court where people go without fear and favor, where issues of competence are not matters to be considered, and then you let the military, people who subjected themselves to a quasi-court called the military court by recruiting or applying in the army as serving officers or as individuals, let them be tried by the military court, and if they are aggrieved, maybe the appellate system again has to be there. That is understandable. But personally, me, like Yusuf Nsibambi, who has never dreamt of being subjected to a military court, so there is no kind of fairness I expect in such a court.
Is it the change of venue or the people in charge of the court?
It's not change of venue. This country does not belong to Museveni. This country is not Museveni's country. It's for all of us, 43 million people. So you should not think that his wishes as an individual, his fears for failing to perform, they must be protected by 43 million under a court appointed by himself. We don't believe in that court. It's like a clan court. It's like a small court under the feet of an individual. So let him be subjected with these other people who wish to join the army not any other person.
Honorable Simambi, is there a line we are missing between governance and maybe politics?
Definitely, and that is a very big mistake for all of us Ugandans. It is wrong to subject the governance of a country and the development in the hands of a person who has never performed. When you look at the history of General Museveni, before he went to the bush, he has never been subjected in a formal system. So for him, he believes in informality and fights, because his background is in pet fights as a guerrilla since childhood. So basically, that is a very big mistake, and it's a lesson. Let Ugandans at whatever level look at the credentials, the resumes of the individuals behind offices. That's why we are suffering. We are under a system of individuals who have never been tested. We are under a system of individuals whose background people are not aware. And we also under a system of militarism. So people, if you are not in the army, then you are nobody. So the kind of leadership we have and governance is in itself crude and primitive.
Even if you looked at it yesterday, definitely the presentation by Honorable Odur had a lot of merit. There are issues which definitely I think the Attorney General or the legal team from the government side has misrepresented and misinterpreted the Supreme Court ruling. Like when you talk about the issues of independence, they say, how independent are these court martials? You are saying they are going to be independent. How? Because independence has so many ingredients in it, including security of tenure. But now if you are appointing these people for 3 terms and you are saying renewable, so somebody will now toe the line of the appointing authority. So that alone erodes independence, because for the judiciary, the judges are appointed for a specific time. You know, I'm going for this term. So they will be independent in making the decision. Nothing, very limited areas where they can sway away. So you can look at that. So to us, that was wrong. The issue, when you come to the issue of the three people who will be in the court martial, it's only one who is a judge. We even try to propose that let all of them be lawyers. How can you allow people who are not professional in the law to be the ones you appear before? So you could see that's not the interest of Ugandans. I think this law is targeting some people. But people don't know that, like you saw with the public order management, a mama who was pushing it, he also fell a victim. So that's why the law say that when you're making law, it should be blind. But if you are targeting some people, it will backfire. So to me, what only needed to be done is court martial should only be in circumstances that are prescribed in the act, like when the soldiers are in the operation, they are in Congo, they are in Somalia, they are in South Sudan. If they mess, that's why the court martial is supposed to deal with the matters. But not in a country where we have the judiciary. Because the judiciary, if you think the judiciary is weak, they are slow, appoint more judges. And we have been appointing more judges, appointing more judicial officers to deal with the matter. Now, you want somebody who is a maturist, because he doesn't know the law, he will not take the process or the legal process of the law. So you want them to handle these matters. So to me, that was wrong. The court martial could only be in those operational areas. But in the country here, these people should be. The example they're giving about Karamoja, it was because the police and the army was limited in those areas. They failed to be in areas, because if the army was there, if police was there, was deployed there, the Karamoja would not be able to rob, it wouldn't be. So it was a failure on the government side. So you can't use that as an excuse for introducing it, because all of us lost people to cattle and to do what. But it was because of the failure of government. And that's why that's why for me, I took even government to court.
So how best would the courts of judicature be empowered to handle such cases?
They provide the resources to them, provide enough manpower. They will deal with it. Yeah, resources and manpower. Yeah.
Are we missing anything in terms of governance and politics?
It is being mixed. You see it there. It's very glaring that it's just politics being mixed with the governance issues. It is there. You see it, that the thing is just targeting some people. You go to other countries, look at the issues of how do you limit me on the boots, it's so-called jungle boots. Tourists use those boots for climbing. How do you say, if you are found with this, you face a court martial? if you are found with a barrel. These are very peripheral things. Yeah. In other countries, people have those things, but there's nothing. Yeah. So why would you? But if somebody kills somebody, there is a procedure. Like what Dr. was talking about, the penal code. It deals on those cases of the murder, specifies all, unless they're defining murder in a different way. So for me, yes, it has passed, but it will catch up with all of us.
So finally, can Parliament still have a chance to clean its reputation? That is, if it has been messed.
You don't generalize it. Don't generalize. Don't generalize Parliament because as you saw, it just say it's those NRM people who have messed it up. But don't generalize us as an institution. Yeah.
Okay. Thank you very much, Honorable.
Yeah, thank you. There's no one who is not who has failed to interpret the Supreme Court ruling, but there's a group which has deliberately misinterpreted the ruling, and that's where the dilemma we are in as a country, because we have people who have deliberately went ahead of government to misinterpret the ruling of the Supreme Court. The ruling of the Supreme Court was very clear. First of all, they said the court-martial as it is now cannot dispense justice. In case they have to, then the following reforms must be made. And the reforms have been very clear. One of them was to provide for competence in the court by way of legislating on the qualifications. Number two was to make this court a subordinate court such that those not satisfied by its decisions can be at liberty to appeal, whether they are civilians or serving officers. This was very key, and this was in the ruling of the Supreme Court. The other issue was there was no clause in the law that provided for the prosecution of civilians in the court-martial, meaning that even the Supreme Court agreed that there must be exceptions. So yesterday, what government did was to bring those exceptions under which a civilian can be tried in the court of in the court-martial. However, the public has been made to believe that as if civilian courts have been removed and every civilian has now been taken to the court-martial, which is not true. What is very true is that no civilian should be prosecuted in the court-martial unless the circumstances which you have given, the exceptional clauses. If you behave like a soldier, you act like a soldier, then the law that deals with soldiers should deal with you. That is basically what we are trying to say. What's wrong with you? If you can acquire arms, a monopoly of the army, you acquire uniforms in the monopoly of the army, you use that to commit a crime, why should you fear the court-martial? You don't even fear the gun, which is a monopoly of the army. Now, why should you fear to be taken through the process where those who offend the law in the army go through?
So, Honorable, what would happen if the same exceptional circumstances are transferred to the courts of judication?
You see, first of all, the spirit, the object of the law is what we should be understanding. The object of the law is to strengthen the disciplinary processes in the army. Everybody understands and agrees with us that you need a disciplined army. Otherwise, we would be saying, why do we have a court-martial in the first place? These are Ugandans serving in the army. If they commit an offense, like those who commit an offense in the civil service, should go to the civil court. But if you believe that the army is a distinguished organization with special work they do, and therefore discipline is very key for them, if you agree with us, then we can now start talking. Otherwise, if you don't agree that the army should have exceptional law to guide their discipline for the good and prosperity of this country, then we may not even engage you intellectually, because you have deliberately closed yourself out to just blackmail government. So the exceptional circumstances should first of all agree that there must be a court-martial for this discipline of the army. However, when the army people connive with the civilians and commit a felony, where should the civilians go? Under one file. One who has committed a crime in connivance with a civilian, and this civilian is saying, no, 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 me, I'm a civilian, I cannot go. So there must be exceptional circumstances to provide for this civilian to be prosecuted.
The question of the timing, because maybe the critics are saying that the timing of this law is ahead of elections, and
that one I cannot comment, because I'm not. I am not part of the executive that introduced this bill. But secondly, this bill had been in Parliament and had been even in the committee for some time. Just that by the time the committee was processing the bill, the Supreme Court made a ruling. Now, killing two birds with one stone, whereby recall the bill, incorporate what the Supreme Court has said. So the timing I don't want to say that the timing is the reason. Otherwise, why did the Supreme Court make a ruling when the UPDF Act was for amendment? Has any Ugandan asked that question? Why? Because circumstances can determine the coincidences, but we cannot say that the coincidence is deliberate. That is just the timing. Yes.
How would you describe a bad law and distance this from being a bad law?
A bad law is a law that has been made to target certain individuals. So it already has eyes on whom to catch. That's a bad law. But this law is blind. And therefore, apart from just disciplining the army, it's going to discipline civilians. Because they know you commit a military-related crime, you go to the court-martial. So that is it. So we don't know who is that person who is planning to commit a military-related crime. So we cannot say we are targeting you, that this law is targeting me, because it is silent and blind on whom it is going to work on. Only those ones who illegally acquire guns, who connive with the army soldiers to commit a felony. So if you are there, then the long arm of the law will catch you. But as for now, the law is not looking for you.
And finally, Honorable, as I let you go, there are those also who are saying that Parliament has succumbed to fear from the executive.
Some of us who have been in areas that were affected by insurgents, particularly in Busia, we had rebels of Force Obote back. And these people were terrorizing us. All the cadres of 1987, 88, all RCs were targeted and killed just by rogues, a few guns in the arms of Rongo people. So you cannot say we have succumbed. And some people they have not put themselves in a situation where the country has fallen back to these insurgencies. Otherwise, any serious Ugandan would love to legislate to make it hard for people to try to destabilize the country.
For me, the timing wouldn't be a problem. That bill has some positives and some negatives. The positive bit is about the welfare of UPDF and the veterans, but the negative is the trial of civilians in the military court-martial. And there were so many issues that were in that bill that needed to be ironed out before it is passed. For example, accomplices in criminality, it was not clear, because if I'm here and someone is with me, I don't have to check if they have a gun or not. But if they come and security comes and finds that that person has a gun, an illegal gun, I'm also now part of it. So it would seem as if every time you want to meet someone, you have to check them. You have to carry a metal detector to check that they don't have something that is not permissible before you are taken into the court-martial, before you are arrested. So there are so many things that needed to be discussed further, and I think, to me, it was not given adequate time. The timing is not a problem, because a bill can come anytime. But as long as it is scrutinized very well and it is given due attention and adequate time for it to be processed, and then public participation. Such a bill needs a lot of public participation, and the people ought to have been given enough time to participate, to contribute, so that there is no rope pulling, here, there, and blame games. And I think that was supposed to be very important.
How would you describe a bad law, and how can you distance this from among the list of bad laws?
Well, it depends on so many things. But the most important thing in this is that the people, because they call us, they think we are targeting, the parliament is targeting people, civilians, They are not understanding that there has to be a criminal element for someone to be arrested and arraigned in the court martial. So they are thinking that we are killing them, we want to kill them, we want, And so that's why sensitization about this bill was very necessary. People ought to have been sensitized to understand the consequences, to understand the elements and the purpose of the bill, which was not, I think, done adequately. So to me, it is something that we need to keep discussing, Even after the passing of the bill, there is further discussion that is needed on sensitizing our people about the merits and demerits of the bill.
Okay. Honorable, finally, are we failing to draw lines between governance and politics?
Well, both go hand in hand, because politics is also part of governance. Governance is also part of politics. So it's all about separation of powers, how best we can separate the role of parliament from the role of executive, from the role of the judiciary. And to me, that's where the biggest problem is. That's where the crux of all the matters is. Because when you look at it, there are accusations and counter-accusations among the three arms of government, which to me I think is very dangerous for the country. There should be trust, created and built based on the tenets of democracy in this country. And to me, once there is mistrust, there will always be conflict among the three arms of government, and which shouldn't be happening.
And public perception is very, very important for successful implementation of any program and any act or law. The public perception and handling of civilian in military court martial has been very negative, because under the judicial system, a judicial system must be presided over by a qualified justice. That means somebody who has studied law, has gone the due process of approval and appointment. The structure of military court martial worldwide does not require an officer who shares the court to be a judicial officer. Of course, the Supreme Court ruled that military court martial must be presided over by a justice of court. That means a qualified lawyer. And that's part of the reform in the bill that was passed yesterday, to ensure that the entire bench are composed of people with the legal background. And so they qualify to be justices of high court. That's a good reform. But secondly, these are civilian. The other issue which the Supreme Court raised was the process of appeal to the judicial structure of the Supreme Court. That was also provided for. But the procedure and management of the court martial does not involve the office of the DPP, that is the Director of Public Prosecution. The investigative arm of the military court martial does not involve police, because police by law worldwide is civilian in nature. and police deals with the civilians working with the Office of Director of Public Prosecution. And therefore, the investigation of military court-martial and the prosecutor of military court-martial are officers of the military. We have separation. A woman is a woman. And the definition of a woman is biological sex. A man is a man, and the definition of a man is biological sex. The military court-martial is specifically worldwide set for military officers. The argument and the discussion that any civilian who carries arms and gets involved in, puts on uniform and activity which are related to military should be tried by military court-martial is wrong. Then that would mean that any military officer who steals property of a civilian should be tried in a civilian court. And that approach and definition and understanding of the operation of military court-martial and the ordinary courts is wrong. It is based on that principle that we believe, and the entire population, including the NRM and non-partisan, across the political divide, all the Christians, all the Ugandans, are opposed to trying civilian in a military court-martial because we have separation. A military court-martial is designed and specifically for battlefield and for resolving of issues of military. And all the military officials during training and recruitment, they understand that if they act contrary, they will be tried by a military court-martial.
So who is deliberately not doing the right thing?
No, it is government, and the proposal of muzzling civilians by trying them military court-martial, where the due legal process does not provide for just and fair system, is an attempt of government to muzzle decent voice of the civilian to create fear and threats. No, we cannot say the parliament has succumbed from the fear of the executive. The enactment of that act against public perception, the law should have been tested. There should have been wide consultation to bring the population to appreciate the need for civilians to be tried in military court-martial. The fact that this process was not conducted, it left the majority of the population to think of suspicion that the intention of the act or the amendment of the bill is to harass the opposition and to harass those who are opposed to the regime, which may not be true. So we want to call upon President Museveni that this bill needs to be, we need to consult the population, we need comprehensive consultation and find the opinion of the public, because the laws are made for the good order and peace of the country. And the power belongs to the people, and we legislate through the people and that parliament.
What is the scenario with the rest of East African region?
That's the practice. Military court-martial is for the military, not civilians. And that is when there have been the practice here, that all legislation, there should be public consultation. I think we have been having consultative process. We have been having consultative process involving the people because we are here representing the people. It is only this bill where government rushed through without giving people enough time to consult the population. Because this is a bill of strategic nature. It does not require for every bill, for every act, for MPs to consult, because we represent the people and we act on behalf of the people. But for a bill that has perception and public opinion and has gone to the Supreme Court, it is just proper that the public is widely consulted and comprehensively, and reports are presented. The people of Toro District, in a meeting of all district councillors and the civil servant, where we had Nijinja, they told me that please don't go to support that amendment.